Okay, I want to welcome everybody to July's Planning Lunches at Noon webinar. It's Zoning Amendment Time 2026 edition. I'm Noah Hodgetts, a principal planner in the Office of Planning and Development at the New Hampshire Department of Business and Economic Affairs. I'm joined by my OPD colleague, principal planner Brendan McDowell. Here's a quick reminder on how to use the Microsoft Teams webinar controls. Please put your questions in the chat and we'll do the best to answer them during the webinar. And if we have additional time at the end of the webinar, we'll hopefully be able to answer additional questions then. Here's the agenda for today's webinar. We are going to begin with, I'm going to give a little bit of outline, a refresher of what is zoning, zoning's relationship to other land use regulations, then talk about existing and soon to be take effect state zoning preemptions, and talking about conflicts, how to address conflicts between state zoning preemptions and what your local zoning ordinance says. And then my colleague Brendan will do the second half of the webinar, talking about what is a zoning amendment, what to consider when you're preparing new zoning amendments, and then talk about the whole process, public hearing and notification process up until town meeting. So just a very quick refresher. It's generally accepted that there are two components of zoning, the zoning ordinance and the zoning map. Municipalities have the option on whether to adopt zoning as a way to regulate land uses in their community pursuant to RSA 674:16 through 18. That's where the zoning grant of power can be found. RSA 674:20 also provides the authority for the local legislative body to divide the municipality into districts in order to accomplish all the purposes of the zoning ordinance. And this is what is referred to as the zoning map. Here's an example from Guilford shown on your screen. All but 18 of New Hampshire's 234 municipalities have adopted a zoning ordinance under 674:16. Municipalities with a zoning ordinance are shown in that kind of tan gray color on this map. And only 6 of the 18 communities that have not adopted zoning in New Hampshire don't have any other kind of land use regulation, such as a floodplain development ordinance or telecommunications ordinance. And then just another kind of good reminder to just kind of make sort of a baseline on all the same information. There's two main styles of zoning ordinances in New Hampshire. Permissive zoning, which usually has a permitted uses, a table of permitted uses or a list of permitted uses, and lists all the uses allowed in the community either by right, conditional use permit, or special exception. And then any use that's not explicitly listed or identified as otherwise deemed to be prohibited. And so that's how most communities zoning ordinances are set up, as permissive zoning, but there are some communities that have prohibitive zoning, some of the earliest zoning ordinances, whereby they actually list out uses that are not permitted, and then it's presumed that any use that expressly uses that are not permitted are otherwise deemed to be permitted. So before you begin kind of thinking about what zoning amendments you want or changes you want to make to your zoning ordinance, make sure you have a good understanding of whether your zoning ordinance is permissive or prohibitive. Here's a diagram showing the relationship between the zoning ordinance and other land use regulations, including subdivision regulations, site plan regulations, capital improvements program, CIP, and otherwise. The zoning ordinance should essentially be thought of as the rule book for your community and should generally be consistent with your master plan's vision and land use chapters. The way to think about this is that the community voted to adopt and implement zoning as a tool to describe and specify the sizes, types, and locations of land uses and developments in your community. And so essentially zoning is part of the means to the way to obtain the community you want and also the community you don't want through regulating land uses. You can also think about zoning as effectively implementing the land use section of the master plan and other relevant sections of your community's master plan. And then here's just one more slide that kind of outlines all the different regulatory functions of the planning board in addition to the zoning ordinance, as well as their statutory references. So whether that is the subdivision regulations, which can be found in 674, and that should actually say 35 and 36. There's a typo there, our apologies. Site plan review regs, which are in 674, 43, and 44, so on and so forth. And then some of the other regulatory functions include growth management programs, impact fees. Planning board's also the regulator of excavation permits, as well as driveway regulations. So with all that said, while we have this pretty broad zoning grant of power found in RSA 674:16, over time the legislator has chipped away at municipalities' authority under 674:16 to prohibit, regulate, or restrict different land uses via zoning through enactment of different state preemptions. For example, many of you are probably familiar with 2025 House Bill 631, which just took effect July 1st of this year, which requires multifamily housing to be allowed in commercial zoning districts if there's adequate infrastructure available. As well as another example of this is 2026 House Bill 1588, which just breaking was actually just signed by the governor yesterday, which will take effect in mid-September and place further constraints on what types of regulations municipalities are allowed to subject multifamily housing in commercial zoning districts to. Well, we don't have time as part of this webinar to go through the specifics of each preemption in detail. This slide gives a kind of pretty good list of the most significant state preemptions, as well as the RSA reference for each. And I have bolded here all the preemptions that have been added or amended in the past 2 years. I know, I'll say just now, I know there is going to be a lot of interest, I'm sure, in hearing about some of these newer preemptions. We are going to do I'll say this again at the end of the webinar, but we are going to do next month's webinar on Thursday, August 20th on all the 2026 planning and zoning legislative changes. So please definitely mark your calendars for that. So addressing conflicts between state preemptions and the zoning ordinance. So generally speaking, state statute preempts a municipal zoning ordinance, except where the statute explicitly states that a municipality may adopt more stringent regulations. So a great example of this is the Comprehensive Shoreland Protection Act, RSA 483-B, sets out the minimum standards for the shoreland setback, has a setback requirement with feet, and then it goes on to say in 43-B:8, Roman numeral 1, explicitly says municipalities may adopt more stringent regulations for shoreland setbacks and other shoreland regulations. However, in the absence of that language, it's generally safe to assume that state statute sets the standard for how a municipality has to allow a certain land use or how it can regulate that land use. And this becomes really important if you think about that. Oftentimes there's not necessarily time from when a state statute is signed into law to when it becomes effective. It doesn't necessarily give the municipality time to amend its zoning ordinance to come into compliance with the statute change. Sometimes some piece of legislation have that kind of grace period, but oftentimes it doesn't. So in cases where the new statute doesn't provide that grace period, the state statute still renders the provisions of the municipal zoning ordinance in conflict with the state statute unenforceable. A great example of this is House Bill 1195 from this year, which the governor signed a couple weeks ago, which amends RSA 674:16 Roman numeral 6, and also creates a new RSA 674:81, which became effective July 2nd upon her signature. Says of July 1st, but she signed it July 2nd. And it did two things. And again, we're not going to go into a lot of detail on this, but just overall, requires family and group family child care for up to 12 children to be allowed by right as an accessory use in the primary structure or existing accessory structure on lots where residential uses are permitted, and not be subject to site plan review if the child care complies with DHHS licensing requirements. Folks, that may sound a little bit familiar to folks. There was a previous law from 2 years ago, 2024 House Bill 1567, which gave the option for municipalities to allow family child care as of right or conditional use permit. This takes away the option to allow family or in-home child care in residential districts by conditional use permit. It also requires child care centers to be allowed by right on commercially zoned land and to be exempt from site plan review if the center complies with DHHS child care licensing regulations and has fewer than 30 children. So despite the fact that the vast majority of communities in New Hampshire will not have an opportunity to amend their zoning to actually come into compliance with this statute if they are not already. This statute took effect July 2nd and is on the books today. So that's a good segue to our next slide, is that while it's best practice to amend the zoning ordinance to comply with the state statute change, failure to amend the zoning ordinance to comply with state statute change does not necessarily mean that a municipality, certainly does not mean that a municipality is exempt from the requirements of state statute. So in the child care case from the previous slide, if an applicant were to propose a use such as a child care center in a commercial zoning district where your zoning ordinance does not currently allow that, or a family daycare in a residential zoning district where you currently require a conditional use permit or do something else which doesn't comply with statute, state statute now allows that. And so that existing provision of your zoning ordinance is now unenforceable. So, and that's just based on the plain reading of the statute. So while can't provide legal, our office can't provide legal advice, I would say that as you have applicants that may learn of these new statutes come in and say, I want to do XYZ childcare, or some of the other new uses that are resulting from some of these new state preemptions, definitely consult your municipal zone attorney on how to handle these conflicts as they arise. I would especially definitely point out to consult your municipal attorney about any potential conflicts, which are with RSA 676:13, Roman numeral 1, that says the building inspector shall not issue any building or occupancy permit for any proposed construction, remodeling, or maintenance which will not comply with any or all zoning ordinances, building codes, or planning board regulations which are in effect. And so that creates this inherent conflict, right, between, on the one hand, having a provision of your ordinance that may be unenforceable because it contradicts state statute, and on the other hand, having a statute that says, well, the building official or building inspector should not actually be issuing building permits for a use or construction that violates or does not comply with the zoning ordinance. And so that, again, can't provide legal advice. I would suggest you work with your municipal attorney as those cases arise. And then just finally here, failure to comply with a state statute requirement may result in costly litigation. So now I'm going to move to a couple of examples of what not to do when amending your zoning ordinance to comply with state statute. I could provide a really long list of communities that have done a really good job trying to comply with state statute, but here's a couple of examples of what not to do. So at the top is what the parking requirement in RSA 674:16 Roman numeral 7 states, which took effect last September. It says, in essence, municipality can regulate accessory parking for vehicles, but shall not require more than 1 residential parking space per unit. The bottom is what this unnamed community attempted to a zoning amendment they proposed, which did pass, which sought to comply with the specific requirement of only allowing 1 residential parking space per unit, by instead requiring 1 off-street parking space and 1 additional designated visitor parking space per unit. This is a clear violation here, conflict here between what the state statute says and how the zoning amendment sought to comply with this state statute. Here's another example of what not to do. At the top of the slide is RSA 67480. This is the new requirement, as I mentioned earlier, that multifamily residential be allowed on commercially zoned land, provided that adequate infrastructure is present. Below is what the zoning amendment stated, which also passed, which confirmed that multifamily is prohibited in the commercial district, and then went on to say, we're only going to provide standards for approving multifamily housing in the commercial district if the town is ordered to do so by zoning, judicial, or legislative relief. Again, what the zoning amendment states and the plain language of the statute are clearly in conflict. Definitely not a good example to follow. So then that begs the question, what happens if you propose a zoning amendment to comply with the state statute, such as the zoning amendment here seeking to comply with the 1 residential parking space per unit requirement, which also sought to remove the requirements for guest parking? And then that amendment ends up failing, as we can see here, failed 1645 no to 1485 yes. So if a zoning amendment seeks to change the language to comply with state statute change, fails to pass, the section of that zoning ordinance is still in conflict with state statute and still remains unenforceable and open to legal challenge. As I said earlier, any conflicts you have with any conflicts or provisions in your zoning ordinance which contradict state statute are open to potential litigation. So that's, I'm sure we'll get plenty of questions on as we see more of these statutes take effect, but that was the first section just on state preemption, how to deal with conflicts between state zoning preemptions and your local zoning ordinance. We're now going to turn to kind of nuts and bolts of the zoning ordinance. So typically a zoning ordinance contains the elements shown on the screen, the bolded items on the second half of the list, including definitions, district boundaries, table of permitted uses, dimensional requirements, and separate requirements for specific uses are typically the subject of zoning amendments. I want you to note here that items such as parking and performance standards, such as traffic generation, noise, lighting levels, stormwater runoff, loss of wildlife or vegetation, or even architectural or design standards aren't on this list. Per RSA 674-44, which details what items a planning board has the authority to regulate in site plan review regulations, many of these items may make more sense to regulate through site plan review. This not only provides the ability to amend these standards without having to go to town meeting, but can also provide more flexibility to tailor these standards for specific sites, less use going through the site plan review process. And then here's just some other regulations, despite the previous slide of putting your uses, in the zoning ordinance and in other performance standards and site plan review. There's still a lot of different regulations on a lot of different topics, everything from ADUs to watershed protection to workforce housing that can still go in your zoning ordinance. So before I turn it over to my colleague Brendan, I just want to give a plug for our zoning amendment calendars. So on our website, at the link and all these slides, which we'll send out afterward, are hyperlinked. You'll find different calendars with key dates about the first and last day to accept petition amendments, the last day to post and publish notice for the first or second public hearing on a zoning amendment, and the last day to hold the final public hearing, last day to place on file with the town clerk the official copy, and a couple of other key dates leading up to town meeting, upon which the zoning amendments are voted. These dates are actually from this year's town meeting cycle from this spring, but we'll be publishing the 2027 calendars sometime in August. So please check back in about next month. We'll be sure to send out our notification and email about that to our list. So assuming you all received the notification for today's webinar, you should also be all set to get the email when we publish our updated zoning amendment calendars next month. And with that, I just see one or two questions here so far before I turn it over to Brendan. Robin asks, how do I determine if our zoning ordinance is permissive or prohibited? Should this be obvious in the ordinance itself? What if it isn't? So yes, it should be pretty obvious. Some zoning ordinances say at the very beginning, this is a permissive or this is a prohibitive ordinance. If you have any questions, if you have the table of permitted uses or your ordinance lists out uses by district, you have a permissive ordinance. If it specifically says these uses are prohibitive, you have a prohibitive ordinance. If that's still not clear and you have questions, feel free to reach out to Brendan and I or our office. Our contact information is at the end of these slides. That's all we got for now. I'm going to turn it over to Brendan now.
All right, perfect. Thank you, Noah. All right, so what is a zoning amendment? So in New Hampshire, zoning changes take the form of zoning amendments. So cities and towns with town councils can adopt zoning amendments at any time of the year, but non-town council towns and village districts can only adopt zoning amendments once a year by ballot at their annual meetings. So the planning board is responsible for the amendments to the zoning ordinance. So the majority of amendments typically come from the planning boards. There are two other ways to get zoning amendments on the ballot. The first is that the governing body can propose amendments as well. And secondly, 25 or more registered voters can also put forward a zoning amendment by petition to be voted on at the annual town or village district meeting. So for the zoning amendment language, one, you want to make sure that you review with the municipal clerk for language templates. So all formats are the same. So use the sections and chapters you are amending to provide a statement if the planning board supports the amendment or not. And three, add clarification, reasoning, justification, a statement on the proposed warrant along with the proposed amendment for clarity, record keeping, and history purposes. However, the governing body and petitioned zoning amendment language cannot be changed by the board or the public. So what is the goal of the zoning change? Trying to incentivize development in a district by allowing additional uses. If you have a district that there's not a lot of development happening and you'd like to see more development of a certain kind, maybe expand those uses. Trying to establish regulations for a new use or prohibiting an emerging use. There's been a lot of news coverage about data centers as an example of this, that towns and communities may want to, look at, changing or adopting new regulations around. Remedying ZBA issuing multiple uses, dimensional variances, or special exceptions. An example that I thought about was perhaps you have a single family zone that has a lot of duplexes and the ZBA is granting a lot of duplexes. Maybe the market's changing in that area and it might be worth it to just allow duplexes by right to free up the ZBA from a lot of those decisions. So possibility there, or an opportunity there. So addressing inconsistencies within the zoning ordinance or with other land use regulations. Also housekeeping. These documents are probably never going to be perfect. There's always going to be minor errors, mistakes, renumbering, reordering sections, cleaning up typos, grammatical errors, anything like that. You could probably tinker with these documents, forever. Complying with state statute changes, which is what Noah just spoke at length about. So, for example, the multifamily and commercial district statute, RSA 674:80 is a really good example of that. What to consider for amendments. So there are numerous cases over a particular use or location of that use. You could consult with the ZBA or your code enforcement officer to work on different language, work with other land use boards like the Conservation Commission, other municipal staff and departments, and see what sections they use and what sections they believe may need to be changed. Reviewing the table of permitted uses and definitions. You should not have a use without a definition, nor a definition without a use. Keep the definitions in plain language. When in doubt, use a dictionary. Specifically, the American Planning Association, APA, has a really good dictionary of planning terms. It's a great resource. You can also review other land use regulations and the master plan to make sure they are synced up and up to date. And if your ordinance cites state RSAs, then add language as amended. So when the state changes the RSA, you don't have to keep track of that in your ordinance, and you remain in compliance with state regulations. Do a housekeeping clause in order to fix typos, and should definitely check with your municipal attorney. Always consult with your municipal attorney. So touching on the petition zoning amendments, which we talked about a little bit earlier or mentioned earlier. So again, 25 registered voters can petition to amend or repeal a provision of the zoning ordinance. Petitioned zoning amendments must be received between 120 and 90 days before town meeting, the second Tuesday in March, April, or May, just depending on where your town falls within that calendar. Petitions are submitted to the governing body, who then forwards them on to the planning board. So at first planning board meeting after the petition period, the board shall set a date for a public hearing on the petition. Petitioned amendments cannot be altered by the planning board, but the board shall state if it approves / supports or disapproves or doesn't support the amendment on the ballot. So the legislative process. So in towns, a zoning ordinance may be adopted or amended by ballot vote of a majority of the voters present and voting at an annual or special town meeting. So towns essentially get one bite of the apple once a year to make these zoning changes. In cities or towns with a town council form of government, the municipal charter determines how a zoning ordinance is to be adopted or amended, although a public hearing on any amendment must be held before adoption, and they can adopt zoning amendments at any time of the year or full zoning rewrites. The planning board must hold at least one public hearing according to RSA 675:7. Pay attention to the zoning amendment calendars and make sure that you have enough time to hold additional public hearings if necessary. So this is again why it's really important to pay attention to the zoning amendment calendars and make sure you have enough time to hold everything. So the public hearing requirements. So 10 calendar day notice, excluding day of posting and hearing before the public hearing, shall be posted in 2 public places in the municipality. Notice also published in in the newspaper of general circulation in the municipality or in the alternative posted on the homepage on the town's website. Any person owning property in the municipality can request notice of all public hearings of zoning amendments and such notice must be provided electronically or by first-class mail at no cost to the recipient. Full text of the amendment is not required, provided the notice adequately describes the amendment and states a place where the full text is on file for public inspection. And this next section is highlighted because it's important. So after the public hearing, the planning board shall vote to determine the final form of the amendment to be presented to the town, which may include editorial revisions and textual modifications resulting from the public hearing. This is RSA 675:3, Roman numeral 3. They cannot, can vote to not recommend passage of the zoning amendment, but they cannot withdraw the amendment. So that's a really important distinction. They can say, hey, we don't think this is a good idea, but they cannot withdraw it. So notification and mailing requirements. Does the amendment change boundary of zoning district affect 10 or fewer properties? If yes, notice of the public hearing must be mailed to the owners of each affected property. Does the amendment change minimum lot sizes or permit uses in a zoning district that has 100 or fewer properties? If yes, the notice must be mailed to the owner of each property in the district. Notice must be sent by first-class mail to the address used for the property tax bills. In the case of petitioned zoning amendments, the petitioner must pay for the cost of notice required under RSA 675:7, Roman numeral 1B. So zoning amendment ballot requirements, 675:3. Before the final public hearing of any amendment, the planning board and municipal clerk should confirm the following language is included in the proposed amendment. So the language would be, are you in favor of the adoption of the zoning amendment to the town zoning ordinances as proposed by the planning board? As follows, insert text. So the full text of the zoning amendment, again, does not have to appear on the official ballot. The language to be inserted in the parentheses of the zoning amendment that would briefly describe the parts of the zoning ordinance being amended. A notation should appear on the ballot stating whether the planning board supports or doesn't support the proposed amendment. And add a statement or sentence explaining the reason for that amendment. So after the second public hearing and the amendment have been voted on by the planning board, an official copy has been sent to the municipal clerk, and they should not be discussed and debated again since they have already gone through the planning board public hearing process. So some best practices for the zoning amendment process. Throughout the year, keep a running list of potential zoning amendments, things you'd like to change, things that come up. Start brainstorming sessions for zoning amendments in the summer, and consider adding work sessions to planning board meetings. So now is a good time to start. Consult with the municipal staff, again, your code enforcement officer, zoning officer, and other municipal boards and commissions. Make ordinance language and zoning amendment language on the ballot easy to understand for non-planners. And conduct extensive community engagement and explain in plain English to people. And another thing that might be a good idea is to provide an optional kind of additional accommodations. For instance, American Sign Language. You could write on your notices that if anybody requires additional support to be able to attend the meeting, they should reach out. And you can find a way to provide those accommodations for people to include as many people as possible. Represent the proposed amendment at public hearing and on voting day, advertise via a voting guide or flyer. I've got some good examples of those coming up. And keep good records of notices and minutes. So best practices continuing. So address existing conflicts between different sections or definitions in your zoning ordinance or the other land use regulations or underutilized or dormant sections before adding new sections or districts. Consider undertaking a regulatory audit to identify and remedy conflicts throughout the zoning ordinance instead of addressing on a piecemeal basis through a few zoning amendments each year. And don't bite off more than the planning board and the staff has time to work on and educate the community about in one zoning amendment cycle. So don't bite off more than you can chew. Unless your zoning ordinance is fundamentally flawed and you are conducting an entire zoning rewrite or transitioning to a form-based code, your community is likely to be more receptive of incremental changes than a wholesale change. So cross-checking against other regulations and the master plan. Again, don't take on too many amendments, and take advantage of RSA 676:12. Which is the building inspector shall not issue any building permit within the 120 days prior to the annual or special town or village district meeting if A, the application of such permit is made after the first legal notice of proposed changes in the building code or zoning ordinance has been posted pursuant to the provision of RSA 675:7, and B, the proposed changes in the building code or the zoning ordinance would, if adopted, justify refusal of such permit. So here's some examples. So again, don't take on too many amendments. Here's an example of a zoning ballot with 8 different zoning amendments. You don't want to overwhelm folks. It's tough to sit there in the voting booth and read through every single one of these articles, and you probably have other things you're voting on as well, and so it can be a little overwhelming for voters to make informed decisions on every single one of these. And don't have all of your zoning amendments in one article. If there's a controversial one in there, it could take down all of the other amendments that are all lumped in together. So again, if you've got something controversial in there that people really don't like, you might tank the whole thing. Just because there's one thing, could all be good, and there might be one thing that's a little controversial. So, split them up, split up the amendments. So don't include the entire text of the zoning amendment change on the ballot. It's better to summarize the zoning amendment in layman terms on the ballot and make the full text of the zoning amendment available separately, so somebody could read that on the side, and just have a nice little description in there. So, and if you can, prepare a voter's guide for your zoning amendment, explaining what they are in plain terms. Here's an example from Barrington. They've got their voter guide from 2026. We'll look at that here as well. So here's a description from Barrington's voter guide from this year's town meeting for an article creating a new form-based code for the town center zoning district. And so they've got the ballot question, they've got a nice explanation, they have notes, and they state down there at the bottom, is it recommended for approval by the planning board, 5-0. So they've got all of the information that anybody could want to kind of make an informed decision. So they're making it really easy for folks to know what they're voting for, which is a great thing to do. So more information is better. So after the vote, clearly mark up the zoning ordinance with the year that amendments have been made, or add a section that specifies each year's amendments. So we've got Bo, an example from Bo here. They do a little summary at the end, while Bristol here marks them up kind of throughout the ordinance. So there's kind of two different ways to go about it. So this is a really good note. The date of your zoning ordinance revision is when the vote was taken to amend it, not when you physically edit the document to incorporate the changes. So as you see here, the vote to amend this zoning ordinance was March 12th, 2024. However, the zoning ordinance for 2024 is said to be amended on either April 3rd or April 9th, depending on where you look in the document. So this is not a good practice, and this should be avoided. So, and it is very important, once again, to involve and include the town or city attorney in the entire zoning amendment process to ensure the substance of your zoning amendments doesn't extend beyond the authority granted in the RSAs and doesn't violate the state or federal constitution. So very important. Always include your municipal attorney. So, and a few final thoughts. So, zoning ordinances are meant to be ever evolving to reflect the changing needs of the community and protection of health, safety, and general welfare. Reach out to local seasoned developers to ground truth the impact of a proposed zoning change may have on a project penciling out. You can never do too much education and community engagement to help dispel misinformation about the impact of proposed zoning amendments. So yeah, people will not get angry at you if you have a bunch of public engagement events and you give them a lot of information. They will be angry at you if you don't do enough. So this is a case where more is typically better. And don't expect change overnight. All good kind of final thoughts. All right, so as we're kind of wrapping things up here, this is a link. So here are a bunch of links to many different resources to assist you with drafting zoning amendments. We'll send out a copy of the slides to all registrants and attendees after today's webinar, which includes hyperlinks to each of these resources. So, take a look when you get a chance. So here is a link to the 2025 changes to the Planning and Zoning Statute, a guide for municipalities, which provides an in-depth summary of 13 different bills from the 2025 legislative session, some of which just took effect July 1st, and describes in detail what these statute changes do and don't require. We will be publishing an updated 2026 guide early in the fall, so keep an eye out for that. And, as Noah said, here are our emails and phone numbers for contacting our office. So Noah and I, along with links to our YouTube library where this will be posted, this webinar will be posted there in a day or two. Feel free to reach out with any inquiries to either of us, or if you have any questions as you go about drafting your zoning amendments and would like OPD's input. We are also happy to provide guidance on specific application or examples of types of zoning ordinances that municipalities surrounding yours have adopted. So if you'd like ideas, we can probably provide you with some examples of what your neighbors are doing. And yeah, thank you all once again for attending today's webinar. We do have some time to take a few questions now. And really quick plug, our next webinar is going to be on August 20th at same time, 12 o'clock noon. And this will focus on the planning and zoning legislative changes enacted in 2026. So this is a big one. And we will follow up with a link to the recording of today's webinar and a copy of the slides, as well as a webinar feedback survey too, if you would like to fill that out. Let us know how we're doing. So yeah, with that out of the way, we do have about 15 minutes that we could answer some questions. let's see, I think Noah's still here. There he is. Okay.
Yep. Great. So, first question is from Henry. How do you decide whether a second public hearing on an amendment is needed? Is this a subjective determination by the planning board? So, the statute 675, I had to pull it up here, does talk about if as a result of the first public hearing, the planning board makes substantial changes or the amendment is substantively altered, then I'm going to hold another public hearing. But that said, Henry, to your question, it can also be a subjective determination. So if there's a lot of interest or a lot of pushback or questions about a zoning amendment during the first public hearing, many planning boards will schedule a second one. I would say that for any zoning amendments that you anticipate to potentially be controversial, to just schedule a second one going in and make sure that you're scheduling out that enough time so that you've left those 14 days after the first one to have the second public hearing still in time in advance of the deadlines for town meeting. Excuse me, lose my voice a little bit here. Brendan, you want to read me the next one?
Sure. Yeah, I could do that. So let's see. The next one, I believe, yeah, so you just read the Henry's.
Yep.
From Doug, Jaffrey still requires planning board review, select board authorization, and compliance with local road standards before issuing a building permit on a class 6 road. Since RSA 674:41, Roman numeral 1C, effective July 1st, 2026, now requires issuance based on a recorded liability waiver and proof of insurability, which parts of our local process remain enforceable. Can we still require planning board review, select board approval, or road improvements?
Great. So thank you for that question. Yes, that is one of the statute changes. Sorry, I'm just trying to pull up the statute here on my other screen, which is why I'm looking away. My apologies. That is one of the statute changes that did just take effect July 1st. I think Doug's summary is correct. Yes, the applicant, the only requirement for getting a building permit on a class 6 road now is that the applicant, as the chat noted, provides this signed and recorded liability waiver. Says I'm not going to hold the municipality responsible. Has a proof of it and a couple of other things, a proof of insurability from that their property is insurable. So if your municipality is still doing anything else, such as planning board review, still, as the statute used to say, allowing for the select board to authorize building permits on the class 6 roads, compliance with other road standards, those are all unenforceable now, as per kind of my initial comments in some of the slides at the beginning of this presentation. That's an example from what you're describing of a conflict between what state statute says and allows and what the local zoning ordinance and local regulations are. From what you've described, again, I can't give legal advice. A plain reading of the statute no longer allows for that option for planning board review, select board approval, or other road subjecting class 6 roads to other road standards. So those would now be unenforceable. I would agree. I would also say on that one, though, if your municipality still has concerns about allowing construction on a class 6 road, municipality still has the option to require frontage on a class 5 or better road. So in your zoning ordinance. So if you haven't done that already, or you don't allow that on your zoning ordinance, That is a way for that statute, for example, to basically nullify the ability to build on most Class 6 roads. Next one. Gonna read me the next one?
Sure. Someone said, laugh out loud. I'm one of the examples. I won't name names. The reason I do it that way is because of mid-year formatting, typo corrections. So I believe this is in response to, sorry, hang on. I believe that was in response to this one. The different dates other than the days adopted. So the reason I do it that way is because between mid-year formatting, typo corrections, and FEMA demanding our floodplain ordinance to be updated mid-year, we wanted it to be clear when exactly the edits were published. If we do mid-year changes like that, what date should we use?
Great. So we got a couple things going on here. Yeah. So two different things going on here. If it's just a FEMA map change per the separate statute, which is 674. I always get it confused. I want to say 56. Let me just confirm that. Which it's this kind of 57, I'm sorry, which specifically says that communities enrolled in the National Flood Insurance Program can amend the map references and map dates in their zoning ordinance without going to town meeting, and the governing body can do that. Yes, I would put if it's just a FEMA map change and that is the date specific to that, then sure, put the date, your zoning ordinance amendment with that map change date. But that's the only case where you can do these mid-year updates. Otherwise, any zoning amendments adopted at town meeting, you should be including stating the amended date that those zoning amendments were voted on at town meeting. Hopefully that makes sense. So yeah, so hopefully those kind of two different cases make sense.
Great. All right, so we got one more question here, but also too, we still have a few more minutes. So if anybody would like to add additional questions to the chat, we do have time to answer a few more. All right, so is there a statutory requirement for the town clerk to quote unquote certify the zoning ordinance? Please reference applicable RSA.
Great. So the town clerk is not necessarily certifying that the substance is correct, but more that the language is in the correct format, and that can be found in 675(3). Roman numeral 5, which is official copies of the final proposal to adopt or amend the zoning ordinance, historic district ordinance shall be placed on file and made available to the public at the town of village clerk's office no later than the 5th Tuesday. So as part of that process, the town clerk is typically going to make sure when they're putting together the warrant that the zoning amendments are in the correct lane or in the correct format as we indicated. Hopefully that answers your question, Kyle. See a couple more coming in here, Brendan.
Yeah, we got a couple more. Yeah, keep them coming if you've got any other questions. So let's see. If there are other ordinances that require a road waiver, is the planning board or board of selectmen requirement null and void as well, not just for building? So another question about Class 6 roads.
Yeah, so I think this is about Class 6. The provision in 674.41, Roman numeral 1, subsection C, about class building is just, Robin is correct. is just about issuance of building permits. So, as I said, there's still nothing that requires you to have Class 6 roads. If you have other language about waivers for Class 6 roads, those could still apply. I'm not totally clear on the question. I will say, though, I do want to distinguish between 67441 IC about this new requirement on the liability waiver for Class 6 roads and Roman numeral 67441, Roman numeral 1, subsection D, which is the process for private roads, which also was amended last year, which does still give the opportunity for planning board comment and review, but also now allows for the governing body as well to adopt an alternative private road policy instead of planning board review. So that's a long way of saying, yes, the municipality and the planning board still have authority over road waivers. Those are not null and void. The authority for driveway and other road regulations can be found in 236, Roman RSA 236, 13. I just want to confirm that that is correct. Yeah, RSA 236, colon 13. And the authority for planning boards to have other authority for driveways, entrance, and exit, regulation of other roads that are not subject to DOT authority. That authority is still there. That is in 236 colon 13, Roman numeral 5. Ballot date or town meeting date? I think, I'm not sure what that question was. Town meeting date. I think the question was, should you be putting what day effective the amendments are? Is that the ballot date or is it the town meeting date? It should be the date they were voted on. So some communities refer to the ballot date as the town meeting date. And it's also going to depend if you're an SB2 community or not, whether you have deliberative session or not. If, say, the vote was March 10th, that vote is the date March 10th. And I think our language, we kind of use the two terms interchangeably, but yes, it's the date you want to note your zoning ordinance is amended as of the date the vote was taken. I think we have time for one or two more, Brendan.
Sure. So let's see. So somebody asked if the state needs to have like a rational nexus for adopting different zoning RSAs or changing the RSAs at the state level.
So I think I understand where the question is going. This goes back to the fact that we are a Dillon's rule state. So the state has delegated powers to municipalities and has authority to take away those powers. The legislator, and you can agree or not, has decided to put some more limits on those powers the last few years with regard to several different zoning preemptions, and there's a reference to parking. So no, there is not, based on the fact, I understand there's a legal kind of, typically and I'm not a lawyer, but there is a legal kind of threshold in other ways of having to have a rational nexus, which I think is what this question is about. No, New Hampshire, by the fact that New Hampshire is a Dillon's rule state, the legislator has authority to give and to take back control to municipalities on these different zoning requirements. Hopefully that is helpful.
Yeah, so we are right at 1 o'clock.
All right, I see one more, but two more. I'll do these really quickly. Would a municipality's decision to require frontage on a class 5 or better road have to be adopted through a zoning amendment, or could it be established through subdivision regulations? So if you wanted to apply everywhere on every lot, it would have to need to be in the zoning ordinance. There is a way you could also, you can require that in your subdivision regs as well. Certainly there's no limit on that. However, that means that would only apply to subdivisions on class 5 or better roads. So that wouldn't stop any building permits on lots on class 6 roads, for example, where the lots are already laid out. It could potentially be a workaround to stop additional subdivision on class 6 roads. So. And then one more last question here. Clarification, what if town clerk certifying zoning ordinance once amended? My understanding of your prior response is the clerk is simply certifying a zoning amendment formally for the sake of inclusion on the warrant ballot. Correct. Yes, that is correct. So we are at time, as Brenda indicated. I want to thank everybody for attending today and all the great questions and participation. We hope you join us next month on August 20th at 12 p.m. Note, that'll probably be a 90-minute webinar just because there's a lot of legislative changes to go through, and I'm sure there'll be a lot of great questions. We hope you'll join us next month. Have a great afternoon.
Thanks. Bye, everyone.